Lay's potato battle, farmers' company and the real right over seed. A farmer was standing in his field in the morning. There was dew on the soil, the rows of potatoes were quiet, but the legal notice that arrived at his doorstep shook his entire life. The allegation was that he was cultivating a potato over which a large multinational company claims its rights. For the farmer, it was a crop; for the company, intellectual property. Imagine the very potato seeing which we only remember a packet of chips. If that same potato becomes the biggest debate in courts, law and farmers' rights, then who should be afraid? This is where the question arises: can any company in India hold so much control over a variety of a food crop that the farmer starts feeling afraid even on his own land? The story begins with a simple snack. A packet of Lay's opens, crispy chips come out, but behind that crunch lies a legal story hidden that most people do not even know about. The name of this story is FL 2027, which is also called FC5 in the commercial world. This is not an ordinary household vegetable potato, but a special variety developed specifically for making chips. It has low moisture and low sugar, which is why after frying, the color, texture and crunch of the chips remain more consistent. This very thing makes it valuable for the snack industry. But the real twist is right here. The farmer standing in the field sees a potato, the factory person sees raw material, and the company sees a protected variety in that very potato. PepsiCo's claim was that it developed this variety, registered it in India and holds breeder rights over it. Meaning, questions can be raised over its commercial use without permission. But farmer organizations asked, if the seed came into the field, the farmer sowed it, harvested the crop, and then used it the next time, will he become a criminal? India's PPVFR Act 2001 was made for this very balance. Plant breeders get rights under it, but farmers also get protection to save, sow, resow, exchange and sell seed. Under Section 39(1) IV, a farmer is considered to have the right to save and sell farm produce of a protected variety, including seed, provided it is not sold as branded seed. On Indian Qanun, this core line of Section 39 became the heartbeat of this entire dispute. Now the story goes back to 2019. Some farmers in Gujarat were accused of growing FC5 potato without permission. A court case was filed and the atmosphere suddenly heated up. According to a 2019 report by Reuters, PepsiCo had even demanded damages of over 1 crore rupees from some farmers, but then amid public and political pressure, the company decided to withdraw the lawsuits. But the story did not end with the withdrawal of the case. The real fight actually began after that, because the question had now moved beyond individual farmers to the entire seed law. Social activist Kavitha Kuruganti and farmers' rights groups challenged PepsiCo's registration. Their stance was that the company's action was against public interest and farmers' rights. In 2021, the PPVFR authority revoked PepsiCo's FL 2027 registration. At that time, it was viewed as a big moral victory for the farmers. But the legal story was not that straightforward. PepsiCo approached the Delhi High Court, and then in 2024 the division bench restored the registration. The High Court stated that mistakes in the application or confusion over the first sale date do not automatically become a reason big enough to cancel a registration. Now the matter reached the Supreme Court. The farmers' side said that if this decision stands, it could become a dangerous precedent for corporate seed control. PepsiCo presented the other side. The company said that it was not going after small farmers but raising questions about commercial cultivation that was happening for rival chips makers. Right here comes the biggest contradiction in the story. The farmer says my land, my seed, my crop. The company says our research, our variety, our registration. In August 2026, the Supreme Court refused to interfere with the Delhi High Court's order and PepsiCo's registration was saved. Along with this, the court said that individual farmers can claim Section 39 protection. Meaning, the decision was not a single line. It was neither entirely the company's story, nor entirely the farmer's defeat. It was a legal balance in which both doors were kept open. Now it is essential for the viewers to understand this very balance. Registration does not mean that all traditional rights of the farmer have disappeared. But farmers' rights do not mean either that a company can never seek a legal remedy. The pattern interrupt is right here. This fight is less about the potato and more about the definition. Who is a farmer? Who is a commercial seed seller? What is farm produce? Where does branded seed begin? If a farmer saves potato from his field and sows the next crop, the law provides him protection. But if that same thing turns into branded seed under a package, label and protected variety name, the story can change. Meaning, The real danger does not arise from growing potatoes in the field, but from crossing that boundary where farming and commercial seed business mix with each other. But the ground reality is not that clear. In villages, seed exchange runs on relationships, not on receipts. Some seed comes from a neighbor, some from the market, some from the previous crop. Now think, in such a system, how will a farmer prove that he falls within the protected right? The court said he can claim protection, but proof will also have to be provided. This is where the fear begins. The law appears to stand with the farmer in the book, but the cost, time and pressure of going to court can be heavy for a small farmer. On the other hand, the company's argument is not simple either. If a company invests money in research, develops a special variety, and then anyone uses it freely on a commercial scale, how will innovation survive? This is why the PPVFR Act is not just a farmers' rights law, nor is it just a corporate protection law. It is a difficult bridge between the two. But walking on a bridge is not easy. On one side is the question of food sovereignty, on the other side is the question of agricultural research investment. And in the middle stands the farmer. This case is big, because in India, seed is not just a product. Seed is memory, tradition, survival, and for many families, the hope of the next season. When a multinational claims rights over a seed or crop variety, the talk does not spread in the village through legal terms. Fear spreads there that tomorrow questions might be raised on my crop as well. And when the company says that it only wants to stop unfair commercial misuse, the industry asks, if rights are not enforced, how will trust in contract farming be built? Right here, the real question forms in the viewer's mind. Will Indian agriculture be able to build a new model between open seed culture and private research in the future? Florida 2027 is not an everyday staple crop like wheat or rice. It is a processing potato, particularly valuable for the chips and wafers industry. But the matter is not just about the variety. If today there is a debate over chips potato, tomorrow another crop, another seed, another trait could stand on this very line. This is the reason farmer organizations raised the issue of food sovereignty. Their fear was that if corporate control increases, decisions regarding farming will leave the field and move into contracts and courtrooms. Food sovereignty does not mean just the availability of food. It also means how much control a farmer retains over seed, crop, and farming choices. But there is another truth of the market economy as well. Consumers want consistent chips, factories want consistent supply, and companies want predictable quality with contract farmers. What is the price of this predictable quality? Will the farmer reduce freedom a little? Will the company let go of control a little? Or will the law draw a new boundary in every case? The Supreme Court's clarification tells us precisely this, that this fight, even after ending, has not ended. The registration survived, but the farmer defense is also alive. Now in the future, if PepsiCo takes action against any individual farmer, the farmer can invoke the protection of Section 39. But he will have to prove his facts. This means that the real battle can now shift from generic debate toward individual evidence. Who was the farmer? Where did the seed come from? How did the sale happen? Was there branding or not? This legal detail seems small, but this very thing can become the difference between victory and defeat for a farmer. Now look at another hidden truth. The packet of Lay's that a common person buys for 10 rupees or 20 rupees contains not just potato oil and spices. Hidden in that packet is also the invisible cost of contract farming, supply chain, seed law, corporate research, farmers' rights, and courtrooms. While eating a snack, we never think about how many rules, risks, and relationships the things coming from the field to the factory pass through. And this is the emotional core of the documentary. A farmer considers his crop as life, the company considers it a standardized input, the court reads it under a legal category. All three are not wrong, but the languages of all three are different. And when languages are different, conflict is almost guaranteed. In the farmer's language, seed is trust. In the company's language, seed is an asset. In the law's language, seed is protected subject matter. Now the question is not who the villain is. The real question is, when a single potato carries three different meanings, which meaning should justice hear first? In 2019, public anger pushed the company back. In 2021, the authority revoked the registration. In 2024, the High Court restored the registration. In 2026, the Supreme Court did not interfere with that restoration. This timeline shows that the law is not a straight road, but a path full of turns. At every turn, the power of the story kept shifting. First, farmers felt the system was standing with them. Then the company got relief. Then the Supreme Court kept the window of statutory defense open for farmers as well. That is why asking who won in the headline is easy, but the real answer is more mature than that. The company's registration survived, but the defense of the farmers has not ended. The biggest lesson emerging from this case is that the future of Indian farming will not be decided in the field alone. It will also be decided in seed documents, contracts, registrations, and court interpretations. And this point is uncomfortable, because the small farmer of India has fought more against weather, water, rates, and labor than against paperwork. Now he will have to understand one more thing: legal literacy regarding his crop rights. Because in the times to come, seed knowledge might become just as essential as soil knowledge. The company also received a lesson. Enforcing legal rights in agriculture is not just a legal question, it is also a question of social trust. If enforcement looks like scaring the farmer community, the brand's reputation can be damaged from the field to the market. But if large-scale commercial misuse happens under the guise of farmers' rights, the incentive for research-based agriculture can weaken. This is the tough middle of this story. Both farmer freedom and breeder rights have to be saved together, but neither can be left unlimited. Now think, how will the Supreme Court statement translate on the actual field? Will farmers know how to claim Section 39 protection? Will companies insert clearer clauses in future contracts? Will documentation on seed movement increase? Will farmer organizations run legal awareness campaigns? This case will be discussed repeatedly in agriculture law classrooms, farmer meetings, and corporate boardrooms in the coming years. Because this is not just PepsiCo versus farmers. This is the question of how India will protect innovation without weakening those who produce from the soil. The packet of Lay's will still remain on shelves. The crunch of the chips will also remain the same. But the story behind it is no longer as simple as before. Now when someone asks who holds the right over the potato, the answer will be, the registration over the variety may belong to the company, but the traditional rights of the farmer are also written in the law. And the real fight lies right between this line. How far does registration go? Where does farmer freedom begin? Who will prove the boundary between branded seed and farm produce? This is the place where the Supreme Court has placed not a final full stop, but a careful comma.
If this video has taught you something new, or if you feel this information should reach more people, don't forget to like and share the video. Your small share can become valuable and useful information for someone else. If you have any questions related to this topic, or if you would like to share your opinion with us, be sure to write in the comment box. We read every question and suggestion from you, because your feedback inspires us to create better content. And if you want to keep receiving such interesting and reliable information about business, the economy, and the world in the future, then don't forget to subscribe to our channel GRT Business and also press the bell icon so that you get notifications of every new video directly. At GRT Business, we always strive to provide you with accurate, balanced, and reliable information. Our news and analysis are prepared based on information obtained from various news agencies, public sources, and public opinion. We make every effort to verify and validate each fact as much as possible. But in case of any possible error or dispute, the responsibility lies with the respective sources. Our only aim is to present you with a correct and trustworthy perspective so that you can understand any topic better.